file in the month of May, 2nd of May. Maybe on Thursday, my lord, if possible.
Not on Thursday, 14th, Friday,
My lord, maybe on Monday then.
Monday. Monday is a holiday. Have it on 19th. 19th.
My lord, Friday then. Otherwise, it's already much obliged, my lord.
Please, your lordship, my prayer is for listing lordship. Similar matter listed on already tomorrow lordship. So kindly matter may be taken along with that matter, series matter lordship.
Matter is listed today.
Tomorrow lordship.
Then what is your prayer?
My matter also may be listed along with that matter lordship.
What matter? What is the
Pensionary benefit matter lordship, series matter lordship, but my matter is not tagged lordship. So
We'll see tomorrow. You make a mention tomorrow.
tomorrow.
When the matters are listed, you make a mention.
But my matter is not listed lordship.
Doesn't matter. You make a mention tomorrow. We'll see. Let the matters be listed tomorrow.
Lordship.
Yes.
Please, your lordship. Your lordship, this is an urgent matter regarding land acquisition by the railway department. No compensation has been paid yet. It's WPC number 8426 of 2024. The matter was supposed to be listed by 2 weeks from the 15th, your lordship, of last month. It has not been listed yet. So I'm praying your lordship would kindly list the matter on Friday, your lordship.
Friday.
Yes, your lordship.
All right, Friday.
Thank you. Much obliged.
May I please, lordship? I beg to mention item number 10, 11, 12, and 13.
Why?
I beg to mention, sir, my senior Dr. A2D is not able to appear due to some personal
You wait, you
difficulties.
wait. You wait. You wait. Let the matters be called up.
My please, lordship.
Yes.
Lordship, the respondents have not yet filed their affidavit.
That's right. So, who's for the respondent?
Mr. SCKR.
What is your prayer?
Lordship, last chance may be given because no, in this particular matter was filed in 2022, my lord.
What is the matter about?
It's a challenge to section 148 notice under the Income Tax Act.
Affidavit is necessary to record the necessary.
Lordship, there was an order passed by this honorable court to keep the records ready in item number 3. Don't know whether they are with the senior or not.
You wait for some time. You please inform the standing council. We'll also put it on the notice board. Standing council, income tax. Just wait for a while. Wait. Huh? Wait. From board is it? Yes.
Okay, in item number 4 and 5, I see there is an IA number 1335/24.
Yes.
It's enlisted. That's an IA for impleadment by a party, but no copy was served to us. In fact, I have checked, the notice is served to a government advocate.
So far relating to my item number 4, my lord, no IA has been filed.
Both are related.
No, my lord. If
Let-
your lordship allow
Lordship,
me
let
to-
me complete. First,
Yes,
let me. The IA, this is in file now. Item number 4 and 5, why it is related? Item number 4, in item number 4, pertains to a direction which is sought from the government regarding supply of documents. But when this inquiry was conducted, then certain development happened which led to the filing of item number 5. So both are connected matter, lordship, and both have been decided to be executed together. So what I pray, lordship, is that IA number 1335 has been filed, wherein a impleadment has been sought for. So, and no copy has been served. So that copy needs to be served to us, and we need to file an objection to it. That apart, as per the last order, which is not uploaded, but as per the last order of the court, the government was supposed to file an affidavit.
So far related.
Tell us what is the issue about.
Lordship, what has happened is that the Lordship, in this case, I'm being led by Mr. Kane shortly, but I'll still satisfy. He is on legs, but still I'll satisfy. The petitioner is a cement company wherein they had 130 bighas of land.
Hmm.
Then the respond in item number 4, the private respondent made a complaint saying that the land is mine. Then a writ petition was filed wherein in the writ petition 4761 of 21, an order was passed that an inquiry will be conducted by the deputy commissioner regarding the ownership of land. Thereafter, when the inquiry was conducted, there were certain documents we sought for, and those documents were not given to us. Being aggrieved, we approached this honorable court in item number 4, seeking for those documents. In that, the documents, there is no affidavit from the government. Now, during the pendency of the writ petition in item number 4, the deputy commissioner in the meantime prepared a report, and they went and they evicted us from our plot of land of which was not within the ambit of item number 4. So against that eviction order, we again approached this honorable court, and this honorable court in the eviction order, in honorable court stated eviction order, and there certain directions were issued. I'll give the directions given by this honorable court. In the directions, there was a specific direction to prepare a report as to the ownership there, because there was no absence of non-contestable map. There was a direction by the honorable court to the deputy commissioner as well as the circle officers to give various reports as to what is the status of the sale deeds, the status of the map, the position, and all those things. That a half complete report was submitted with a prayer saying that they require more time to give a report. It was in that backdrop that case had been listed. Then, on the last occasion, the honorable court was pleased to direct the government to file an affidavit in the cases.
Hmm.
But today's, I just see that there is an IA for implement also.
Hello, may I submit my love? What my learned has submitted my love? Some part my love, actually not correct my love. What happened my love in the instant case my love for item number 4 my love. First they have asking my love, this is the second round of lead petition my love. They are asking for a complaint filed by the my love, All Borough Student Union my love, which has been filed. I filed through All Borough Student Union my love. Then second, what happened my love, this honorable court has direct specifically my love. If your lordship go through that order my love, everything will be clear my love. Page 92 my love, 94 my love.
Oh.
Of my love, writ petition my love, item number 4, 8462/2022. Lordship kindly come to the para 8 my love.
Yeah.
First they are asking mainly my love for my love complaint petition and one letter of the deputy commissioner my love. Para 8, page 97. We are viewed that minor discrepancy cannot be reason to interfere with the notice in respect of inquiry on the allegation that the land under restriction alienation under chapter 10 of Assam Land and Revenue Regulation 1886 had been alienated, transferred in the name of person who are otherwise not entitled to hold such land, and further the land purchased by the complainant Mansingh Rongpi is also being claimed by the writ petitioner Purvanchal Cement Private Limited, to who have been purchased by them. The bigger cause of the complainant need a hearing, but again the same must be done by following due procedure of law, by giving adequate opportunity to the petitioner. Accordingly, without interfering that he notice, that is important, we require the petitioner to appear before the circle officer, Sonapur Revenue, either personally or through its authorized representative, upon their appearance, and the circle officer to provide the petitioner with their entire set of documents sought to be reliant against them as to the enable to petitioner to form his objection. The document which has been relied, only that copy should be given to the objection, if any, to be read before the circle officer. After giving an opportunity of hearing the petitioner as well as the original complainant Mansingh Rongpi, the circular may pass reasonable order, may be advisable under the law. If the purpose of the notice circular officer conduct inquiry, the circular officer may submit a report to the deputy commissioner for taking appropriate action. Again, at the same time, if certain documents which should be necessary for the inquiry circular officer are in possession of the petitioner, it is felt necessary that if the document would be necessary for the purpose of her hearing, the circular officer shall inform the petitioner about the particular of such documents, shall make make document available. Accordingly, the petitioner or the authorized representation appear before the circle officer. Date has been mentioned, my lord. On 19/9/2022 at 10:30 a.m. On his appearance, the circle officer shall provide the petitioner or its authorized representative required document that they may require to form the objection, and the said date, circle officer shall also inform the petitioner of his representative about the document in their possession, which the circle officer may require. According to petitioner, file an objection if any there appear again on 10/10/2022. Again, date has been mentioned, my lord. This honorable court, my lord. For which date the actual proceeding before the circle officer shall be started, and the same be brought to it logical and within a period of 2 months thereafter. In the hearing, circle officer shall also inquire the complainant, Monsing Rongpi, that this land was parcelled, had registered deed number so and so, sale number so and so. That deed is, my lord, also, my lord, forged document. That I am not coming on here, my lord. 30/12/2000 is presently owned by the petitioner Purbanchal Cement Private Limited. The circular upon perusal of the record shall form an opinion whether the land purchased by Monsing Rongpi had registered deed number 9447 serial number 14 has been illegitimately owned and possessed the petitioner if you take appropriate action under the law. The conclusion that the circle officer may arrive be informed to the deputy commissioner shall necessary stop for initiating civil and criminal proceeding as the case may be, or both if the inquiry will complexity, any legal, illegal or criminal act being done by any parties. And a copy. Then, my lord, they have, my lord, first they have this document. Copy of deed number, so in the next page, my lord, 99. Deed number, damage certificate, party copy of my lord, permission number, certified copy number, Jamabundi Dag number, so that document has been given. What happened, my lord? They know very well, my lord. They are in trouble. They are producing some forged document. The document is not available, and land is belonging to tribal belt and block. Then they are asking, my lord, my lord, page 113. My lord, I said, my lord, it is impossible document. Why I say impossible document? They are here before law security, page 113, my lord. Have you also got it? Page 113.
No. Pursuant to the earlier order,
Yes, my
there
lord.
was the direction to the circle officer to provide you with all required documents,
Yes,
then pass an order.
yes, my lord.
Now, the first writ petition you have filed because these documents have not been furnished.
Yes, my lord. Document has been furnished as per first petition. May I complete? First document. I'm submitting. Lordship,
I'm
kindly
the
bear,
petitioner, so
kindly bear it 1 minute, my lord. What happened, my lord? Earlier, they are not advocate. I should not mention the name of the advocate. He is a very cunning person, my lord. He's asking the cadastral map, my lord. Cadastral maps mean, my lord, cadastral map all hold the villages. It is this cadastral map just like in this room, my lord. Cadastral map. That cannot be submitted, cannot be given, my lord. And he also knows very well. He has produced the trace map of that particular land, my lord, surrounding land in this writ petition, also second writ petition. So the circle officer said it is not possible to give the cadastral map. How can cadastral map? He can verify. It is a, my lord, big map, my lord. So he what happened, my lord, filed another this writ petition. And my lord, he is asking for cadastral map, my lord. It is not possible, my lord. Let my learned senior friend has submitted, my lord. So this way, my lord, he is dealing tactics, my lord. He want to, my lord, not to dispose of this petition. Because civil code has been barred, my lord. Under chapter 10, Assam Land and Revenue Regulation, my lord. Civil circular officer is the appropriate authority. Let this matter decide, my lord. And my lord, state map will
Now,
give.
circle officer, has he passed any order?
no,
Yeah,
there is nothing on record. That's
I am submitting before your lordship is there, my lord. In this case, my lord, I'm very sorry to say, my lord. Circle officer also played the role, my lord.
now.
This is my, and if you, I am submitting, my lord. This is I can show that in second case they have categorically stated this land belong to tribal belt and block. This honorable court has said you give before opening that when the factory has been locked up, my lord. This honorable court has someone order to us. This honorable court first he has given undertaken that he shall not open the factory on tribal belt and block, my lord. He said,
No,
give that,
these are
that order I read,
These
my
are
lord.
all
And report, my lord, has, my lord, said that their land belongs to tribal belt and block. My lord, what more necessary, my lord? Let till today, my lord, I am not getting that undertaking. That part,
How have you got the land?
Lordship, there are sale dates, permissions which are annexed with the documents, everything. Now, Lordship, what has happened? What the story, the whole story is that when the first repetition was pending, the report was prepared behind our back, and the report, my learned senior has shown, it was pertaining to a particular plot of land out of 130 bighas. It was only a particular plot of land of 4 bighas, which was being under question. Now, what had happened is that when this report was supposed to be made by the circle officer, which they say is with us, he went beyond it, and he went and evicted us from the plot of land, which was not under the preview of this investigation report. That apart, whatever be it, then we came to the Honorable High Court. The Honorable High Court stayed the eviction order. Once the eviction order was stayed, we could not open the factory because there was some clarification required regarding the interim order. Finally, we filed an IA for a clarification of the interim order. That pursuant to that, finally the order was passed on 10/8/2023. That may be perused once. 10/8/2023 of
Hear what the circle officer has to say.
they have to file an affidavit in item number 4.
Mr.
That is the order.
item
that
number
was
5.
4 also.
No,
That-
no.
There is
4
a-
also.
There is an order.
So that affidavit has to
My
be-
lord, I am sorry to say, last 8 months, my lord, no affidavit has been filed by the government, my lord. Because they are giving, my lord, protection to this particular people,
I
my lord.
object to that.
And I pays 129. Your lordship kindly go to pays 129, my lord. If your lordship pays 129, my lord.
Wait, let us hear the governor.
Yes, sir.
Yes, yes.
Earlier there was a problem, and we say that they were
No, we don't know what you want. No, Mr. Talukdar, there is a liberty given to you to file an affidavit. If you don't file it, we close it.
But I have received the communication now that the officers have issued a eviction.
Election, which election? Are they anticipating any more election?
They were
Which
busy.
election?
We filed on 2022, this case. They filed, sorry, my lord, they filed. this
We
case.
filed.
Yes. I know, my lord, this will never come, my lord. And this way,
And-
my lord, and today IA has been filed, my lord.
1335 or 23 without any copy to us.
That, my lord, would be happen. I don't know who filed this.
Even I also don't.
Where have you produced any trace map in the proceedings to show
Yes,
that?
No, we have produced. It is all.
They
annexed
produce,
out
my
of-
lord. They
We have
have
all
produced.
the trace maps we have produced,
produced, my
certified by
lord.
the circle officer.
Certified by the circle officer, test map has been produced. Yes, my lord, correct.
Because I am.
No, what does this trace maps reveal?
Test map reveal the land belong to tribal. In
No,
their report has said, I can show you, lordship, in next case.
Where is the report?
Yes, my lord, in second case, my lord. Report is on the record, I think.
8/9/23.
But they are not filed. Report has been produced, my lord. Yeah, ma'am. Report.
8/9/23 lordship, there is a report.
Report, my lord, last page. Your lordship kindly go to the last page,
First-
my lord. The last page, not my lord. That's my lord, letter dated 8/9/2023 to the Deputy Commissioner Kamrup Metropolitan District. Letter number SPR High Court 1/2010-1309. They have stated all the land belong to tribal belt and block, my lord, second page. That on perusal of the letter, following record are found in the name of MS Purbanchal Cement Limited, Sonapur Soritari, and Dag number mentioned, land fall under South Kamrup tribal belt. And another important thing is that, my lord, there is a division bench order, my lord, standing order of the division bench. Division bench has directed all the land of South Kamrup tribal belt and block should be evicted. Otherwise, their officers should be punished. Division bench order is also available, my lord. I have, my lord, given that order also. If your lordship want to see the order, that is also available with me, my lord. So, my lord, how can this case be running this way, my lord? My humble submission before your lordship is that. And there is a order passed by this Suman order to Diana. Yes, my lord. order passed by this honorable court, when my lord interim order has been passed, that until such time aforesaid is completed, respondent shall not interfere the operation of the cement factory, Schedule A and B land. This direction, however, within the 2 weeks, the petitioner written undertaking before the respondent number 2, agreeing to vacate any Sarkari land or land falling to tribal bill.
Lordship, may
That my
This
lord
is-
undertaken till today I am not
no,
getting. that.
these aspects have been already argued. Lordship, may
That
please
is
to
what-
peruse
no,
on
no,
order dated 4/4/23.
That is the problem, my lord. This is tribal bill land.
4/4/23.
How can he give the undertaking? If he's given under, is given false
What is the
undertaking.
meaning of non-cadastral village?
There
Not,
is no map.
not there.
No, that I know.
Yes, my
But
lord.
what is the implication? What is the implication of land being within the non-cadastral village? Or non-K, as it is called,
The right map is,
Yes, my lord.
one map is,
right?
that is not.
No, no. So how does one find out whether this land is in tribal belt?
There is an order of the Honorable Justice, my lord,
Surana.
Surana, my lord.
Lordship,
That can be
4/4
do within 24 hours, my lord,
4/4
from the Google's.
24 order. All these aspects has been taken.
My humble submission
all these
before,
aspects.
before your lordship is that, my lord.
Whatever has been
Lordship,
submitted.
I am not on that, my lord. My submission before your lordship, since the item number 5, your lordship may, my lord, grant time. So for item number 4, my lord, that can be sent to the, my lord, circle officer to decide the matter. They, my lord, intentionally really, they
There
annex
is
this.
a communication here to the government advocate
Yes, my lord.
where they say that patta number 1, 4, 3 and 5 under tag number 2, 3, 4 are cadastral land. Rest of the land are not cadastral.
Yes, my lord. But it is,
Therefore, they are unable to find out.
this is within the domain of my tribal belt and block, my lord. My submission is that, my lord.
Therefore,
Yes, my lord.
therefore, what we want to know
Yes,
is that how do you correlate non-cadastral land
yes,
with the
sir.
tribal belt? What is the correlation?
No,
That's
no,
Lordship,
no,
order dated 4/4.
no, my lord. My
This
humble-
answer is there in order
no,
dated
no,
4/4.
my humble submission is something different.
That exact
Tribal
question
belt
and
and
query. there was an
Land
answer in
under
4/4.
circumference tribal land belt and block, my lord.
Item number
If
5.
your lordship go to the tribal land block, that the whole area has been defined, my lord. Whether it is cadastral, or not, all fall within the tribal belt and block.
Where
My
is
lord.
that order?
Order dated
Yes, ma'am.
4/4 in the item number 5.
Hmm.
May I read, Lordship?
Yes.
Heard Mr. K. N. Shori, Learned Counsel, Assistant such and such. Also heard Mr. such and such. Mr. B.J. Talukdar, Learned Senior Counsel, assisted by Mr. P.K. Midi, Learned Counsel for the Revenue Department, has submitted that as the Venn Dyke map is not available, the concerned land revenue authorities are seeking assistance from the Director of Land Records to complete the survey of the part of the land occupied by the petitioners, which is non-cadastral mapped area. The modalities of seeking assistance and the manner of assistance desired from the Director of Land Record are not very clear. With the extent of technology the country is now having, which includes availability of coordinates in the Google Map and in many other applications which are available in mobile, the mapping of an uncadastral mapped area would not be very difficult, more so when the petitioner has annexed photocopy of the maps purportedly prepared and authenticated by the Circle Officer Sonapur Revenue Circle, annexer such and such. The respondent authorities are required to understand that in this case, there are two aspects to be considered. First, the interest of the petitioner who is seeking to run an industry, and the second is the objection made by the respondent number 5 who claims that the land is a tribal belt and the provisions of Chapter 8 of the Assam Land Revenue Regulation 1886 has to be followed. Therefore, any delay in the completion of the survey in land is found to be against public interest. Therefore, the court is inclined to direct the concerned authorities who are in charge of conducting the survey in connection with this case to provide appropriate directions which can be understood by the court to the learned government advocate as well as the learned senior standing counsel for the revenue department, and they shall also explain the nature of assistance required from the Director of Land Revenue, Land Records, and why the currently available mobile technology cannot be used for completing the survey when two maps are referred before exist. Insofar as untraceability of the 7 out of the 20 sale deeds in the office of the Sub-Registry Kamrup Metro Guwahati is concerned, once the respondent authorities accept that 20 deeds were registered, but they could trace out only 13 in respect of 7, the essential information about the name or names of the parties can be available in the registration register or in the thumb impression register. Moreover, if the registered sale deed and or registration or other registers are lost from the office of the sub-register at Kamrup Metro Guwahati, the sub-register Kamrup Metro Guwahati shall explain to the court as to what steps are lawfully required to be taken if a registered document is lost from their custody, and he will also explain which of their staff in their office is sought to be protected by not lodging an FIR if the authorities have knowledge of that the said sale deeds have already been lost and cannot be retrieved. The sub-register shall provide the names and particulars of their concerned officials and staff to the court who during the relevant period of time were in charge and or custodian of the 7 untraceable deeds. Such information shall be sent to the learned government advocate. The learned government advocate shall transmit a downloaded copy of this order to the concerned respondents so as to put them to notice of complying with this order. The senior counsel for the petitioners has submitted that pursuant to the order dated 10/8/2023 passed by this court and undertaking as required by the order has been furnished to the deputy commissioner within a few days of passing of the order. This statement is noted as agreed by all sides. The list on such and such day. Regarding the undertaking and all those things that has been already taken care and duly taken care by the honorable court, noted by this honorable court. We have submitted and we have copies to the effect also. Regarding what had happened, Lordship, is that on last occasion, this report has to be from the government and they have to all this aspect. The honorable court on last occasion said there are two interests. So the government has to give.
Government will do the mapping as per their accepted protocol.
Yes, Lordship. That's
So what is the
so this order,
that is expected
Lordship.
now in place for surveying of unsurveyed land? Stating what? Seeking what?
What kind of assistance that have to be provided by the bank?
What information is he seeking? He's the person responsible. He's in charge of the revenue department.
But these things are done by the bank.
The direction of the court to indicate what assistance the revenue department requires from the director of land. And he is writing a letter asking them what assistance you can provide. What kind of a letter is this?
So we had communication with the- order of the-
So if the circle officer did not have the required map, how did he come to issue the eviction notice? He was not posted with which land is within the tribal belt or which land is not or is outside the tribal belt. How did he come to issue the
Non-pedestrian area.
That is not correct, my lord, as per my. My lord, whether it is
Eviction-
cadastral, non-cadastral, the block has been, my lord, defined and it is under the tribal belt and block, my lord. That is unit.
where is
So,
that order of the division bench?
yes, my lord. This is Kuddut Bola. Yes. Para 8. Okay, so lordship kindly go to the from para 8. What order has been passed? And your lordship will find this land, my lord, South Kamrup tribal belt and block, my lord, in my lord. Page 47 has been mentioned and 51. Your lordship kindly look, the highlighter was 47 and 51. This, all the order is contrary to the order passed by the division benchman. 47, this is South Kamrup tribal belt, all the land belonging to that South Kamrup tribal belt and block, my lord. Page 47, that is, and yours is the order of the honorable division bench.
Where is the land situated? This land?
130 bighas lot.
Where? Which area?
Schedule is given in
South Kamrup tribal belt and block, my lord.
page 30 of my petition. Two schedules are given.
Serial number 6.
All these aspects, since it's a 130 bigger land, because we have enough, which have annexed to the annexed to the writ petition, trace map of the whole land, which is at page 246. So the whole land was purchased in fact, till 2022, we have been paying taxes indirectly of all the land that we have annexed, of the total 130 bigger.
Does it give you any right?
Lordship, there is a sale deed. There is a sale deed. Mutation order.
no,
That sale deed is a
There's
title
not
document.
sigma on that if that merely because you are paying taxes.
No, Lordship, there I've been paying taxes pursuant to a sale deed.
One
Once
thing,
the sale deed has
Yes, some of your sale deeds are not traceable.
no, they are
There is
not
a-
traceable means it is at their behest. We have the sale deed. We have the
in
original
our
sale deed.
reply affidavit in next
So
case,
they have said,
304, page 304, my lord.
Lordship, the government has
Categorically,
to say about the
sub-register,
sale deed.
sub-register has said, these sale deeds are not available, these 7 sale deeds.
So
All are
it's-
forged
it's-
documents, have 7 sale
Now
deeds.
forged or it's not forged, it is for the government will say, it is, they are the custodian of the registered sale
Check,
deeds.
my lord.
Now a
Sub-register-
private party, now regarding
my
the
lord.
private party
Sub-register
saying
in our
making this claim
RTI
is
has,
not acceptable.
sub-register in our RTI
It
categorically
is seen
said,
that the
this sale
respondent
deed is
five,
not available.
respondent
Page
5 is all words of the respondent 5 are the ultimate truth. Whatever we are saying or the government is saying is something which has to be looked
I
in the eye
am,
of
what I
survey.
submitting, I
He
submitting on
has
the
no
record. I
document
am
to come.
submitting a record because he is my lord representing my lord stronger section of the
You
society.
bring this on record.
Yes, my lord. I
You
am,
bring this on
yes, my
record.
lord. I am from the weaker section of this. That is why government is not helping me.
He has no title
Government
document.
is meant for the weaker section.
Yes, my lord. Weaker section. Only purpose of my lord, fourth weaker section is required, my lord. Otherwise not.
But
Yes, sir.
but
Yes, sir.
I don't know if they are able to engage you, then perhaps they are not as good as you think.
I am a small boy.
Alright. You bring this order,
Yes, sir.
if you want, if you want,
Yes, sir.
bring this order on record.
Yes, yes, ma'am.
But Mr. Talukdar, this is not what the order of the court said. Court's order is to inform what assistance they require. Why such a letter is written by the DC? He is an IAS officer. Take down. In both the writ petitions. As per last order, the government advocate was permitted to file a detailed affidavit covering the issue as reflected in the order dated 4/4/2024. Stop. Today when the matter is called up, Mr. Talukdar has placed before court copy of the letter. What is the date of the letter? Has it actually been issued? Has produced the copy of this letter has been issued, supplied to the government council by the district commissioner, Kamrup Metropolitan District. Copy of the communication, undated communication has been furnished to the government advocate. Wherein copy of the undated communication to the Director of Land Records and Survey has been furnished to the government advocate, which is placed before the court. The communication reflects that the District Commissioner, Kamrup Metropolitan District, has by the said communication, the District Commissioner, Kamrup Metropolitan District, by referring to the order of this court, dated 4/4/2024, has requested the Director of Land Records to furnish the required information pertaining to the process to be undertaken for survey of NC means non-cadastral land under Solutari NC village of Sonapur Revenue Service, the part of which is under the possession of the present regulation. So, learned government advocate submits that as per the instructions received, no further information has been supplied by the District Commissioner, Kamrup Metropolitan District. Para. The order dated 4/4/2024 passed by this court has categorically directed the concerned authorities in charge of conducting survey in connection with this case to provide appropriate instructions which can be understood by the court to the learned government advocate as well as the learned senior standing counsel for the Revenue Department. And they shall also explain the nature of assistance required from the Director of Land Records and as to why currently available mobile technology cannot be used for completing the survey when two maps as referred before exist within court. Para. It appears that as a sequel, as in pursuance, in deference to this order, the above communication referred to has been issued by the District Commissioner, Kamrup Metropolitan District. So, however, as directed by this court by the order dated so and so, the process to be undertaken is not reflected in this communication, nor has the government advocate, learned government advocate has been posted with the required instructions to place it before the court. So, in view of the submissions made at the part, we permit one final opportunity to the respondent government department to complete their instructions and place it before the court. The process that is required to be undertaken for surveying the non-surveyed land as has been directed by this court by the order dated 4/4/2024. So, para. Meanwhile, Mr. NNB Chaudhary, learned counsel, appearing for respondent,
Five.
5 in WPC number 2448, 2440.
2440.
Both in five, no? Both
Both,
in,
both five.
both five.
In the first matter, I don't see any 5.
Any no. Sir, kindly allow me first.
There is no 5. Oh, there is.
Sorry.
Impleted. Respondent
Include
five-
the respondent five.
Respondent number 5 in both the writ petition submits that he'd like to bring on record the directions passed by a division bench of this court in PIL number 78 of
Sir.
2012 by the order dated so and so, whereby it has been held by the division bench that the entire South Kamrup belt
Bell, my lord.
has been recognized, has been declared to be a South Kamrup
Tribal
tribal
bill.
belt.
South Kamrup tribal bill.
South Kamrup tribal belt has been identified, and
Mm.
a direction is given that areas in illegal occupation of non-tribals
Yes, sir.
and other persons who are not eligible to hold the possession of land be evicted from by following the due process of law. So, he submits that this order will have relevance in the matter. Therefore, he would like to place a copy of this affidavit. Copy of the order by way of an affidavit. Matters are directed to be posted again in the month of July. Date to be fixed by the next week.
Yes. Hmm?
The respondents are permitted to complete their instructions.
Lord, kindly fix a date, my lord. July.
22nd
Yes,
July.
sir. And a small pair, my lord. He has submitted undertaking that was not produced by the government also, my lord. In this order passed by the Honorable Justice Suran, so and so, my lord, that he
That
has
is-
given undertaking that this land not belong to the tribal belt and block before
No,
he.
no, that is not the undertaking.
Order, I am reading the order, my lord.
That is not the undertaking. It's clear.
Yes, my lord, I am reading, my lord, I am submitting record. You know.
All right, so what do you want today?
I want that the particular undertaking which has been submitted may be served on us, my lord, or government produce, my lord.
The petitioners are at liberty to place before the court any undertaking or any material to show
Yes,
the land on which the cement.
Lordship, that is not the order, Lordship. That will
Ma'am,
be
madam,
reading, that will be
this
reading-
direction,
Liberty.
I am reading, my lord, what direction? This direction is however subject to condition 2 days from today.
10,
The
10.
petitioner furnish a written undertaking before the respondent number 2, agreeing to vacate any Sarkari land and land falling tribal bill if the same is found to be there.
If
in
the same is found to be under, that is the part he is not reading.
No, my lord.
So he
If
is
that,
saying-
my lord,
would-
whatever undertaking he has submitted,
No,
the copy may be served to
No,
us. my
that
lord.
is, he is saying that I have to say that I'm not. I'm
If he is
taking
not
occupation
illegal
of tribal
land is undertaking, let them give
The
the
undertaking is on a
I
different
want
level.
undertaking because
And that aspect has been dealt in the honorable court in 4-4. Already the court has.
my
said this is
humble
noted by the-
submission, why he was so, my lord,
No, I have the
reluctant to,
undertaking.
I am
You are-
submitting, my lord.
You are entitled to file an application seeking vacation or modification of the imprimatur
Yes, my lord.
if you want.
Lordship, let him file.
File it if you want.
Let him file.
My
Lordship, Nothing may
humble
be
submission
reflected
is
on
not
the
that, my lord.
undertaking.
I want to say why he is reluctant to submit
Let
this
the government say that we have
undertaking
not
before
submitted
the
undertaking.
court, my lord. And government, why it was not submitted before the court, my lord. That is the game, my lord.
Government is still trying to find out how to survey the land.
That will,
From,
my
that
lord.
is what is apparent from the letter.
Had we have not submitted the
The
undertaking.
way the
has-
government is doing, my lord, my life has been completed, my lord. Whether my daughter will get or not, I do not know. My lord. So bless me. Yes, ma'am.
List again in month of like 22nd,
Only date may be fixed. ma'am.
22nd July.
Yes, ma'am.
What about the IA?
We had not received any copy.
You have filed an IA. You have filed an IA for what? Implement of whom?
In this case,
Who?
he is one of the complainants. Your Lordship. He has complained about this land, your lordship.
He is also a resident of the tribal.
Yes, your lordship. And
So why do you want him to be implemented?
lordship, because your lordship, this has been pending for long, your lordship, and in fact, it is under the tribal belt, your lordship. And therefore, your lordship, I am one of the complainant, your lordship, against the occupation of tribal belt by the petitioner, your lordship, company, your
That is
lordship.
for the government to decide. How are you a necessary?
No,
party?
on the basis of your lordship, our complaint, your lordship, this has been, the entire process has been initiated.
Is
That's-
represented by Mr. Chaudhary.
He is also, your lordship, one of the.
All right.
Lord.
Heard Mr. S. Bothakur. Issue notice returnable on the same date, 22nd.
Lord.
Who appears for the respondent?
Same respondent.
I'll be appearing. I do not have the copy. So I don't know.
Mr. Korpuzari for respondent 1, Mr. D.K. Talukar for 2, 3, 4, Mr. N.N.B. Chaudhary for 5.
And for 6,
And there is no 6 here.
Purvanchal Cements Limited area.
Where the petition?
And,
Phase 3, Your Lordship.
and the writ petitioner, Mr.
Ajeda.
R.J. Das appears for the writ petition. Stop. Since the the parties are represented by the respective councils, notices the way the extra copies be furnished within a period of 1 week from today. Objections, if any, may be filed with the.
Copy may be considered.
I'll wait.
Extra copies be furnished to the respective council.
Deeply obliged.
Obliged.
When we do matter. Take back all the TPL.
I was supposed to file a affidavit, but if it needs further a week's time, I have already received instruction and the Paravich comment also, Lord, because affidavit will be necessary in this.
Mr. SCKL, standing counsel income tax, please for further 2 weeks' time to file affidavit. Prayer made is not objected to by, yeah.
If it could
Accordingly.
be recorded as Dr. P. Agarwal.
Hmm?
Dr. P. Agarwal.
Dr. PR. Accordingly, the matter stands adjourned to be listed on 22nd of July.
22nd.
Interim orders, if any, passed earlier,
Lordship interim order is there.
will continue.
Much of.
Lies.
May please, Your Lord.
Yeah.
Well, I have given list of dates to the deputy record,
What is it that you want?
my lord.
What is the matter?
Issue, my lord. Petitioner before lordships, were the owner of land of Sorusajai Stadium. Some portion of it is bad time telling. That land was acquired for construction of stadium, that Sorusajai Stadium.
Yes.
Thereafter, as on date, main issue is that neither compensation has been paid nor allocation of land was there. Up to this third round of litigation, my lord, it is a third round of litigation. What happened? From the accord, it is seen that in place of that land, in lieu of that land will be provided in other area, that is North Guwahati area. The correspondence is going on up to 2018, up to 2020, my lord. So far it was allotment of land only. Now, suddenly, by last year, one affidavit has come, my lord. Last affidavit has come from the government that we do not have land. Now, question will come, my lord, here, is whether if land cannot be provided, then he'll be entitled for. Last occasion, your lordship worried about that. That was whether land was any. That lordship will get it 16/5/2024, my lord. So Chetty Talukdar has time to return any award. Supper acquisition 18/4 was passed in respect of the parcel of the land being belonging to petition. Here, my lord, this even yesterday I have gone through. This is now the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement, Assam Amendment Bill 2022 was introduced.
One minute.
My lord.
On behalf of respondent 6, who has filed the affidavit?
Deputy Commissioner.
Yeah, who is the counsel who has filed it? Who has filed it?
This is one D. Sharma.
Who is Rajiv Boro?
Oh, that additional affidavit by me.
This is the.
Affidavit in reply.
No, this is
Yes, yes.
additional.
I have filed. my lord.
You filed.
I have filed affidavit.
You've enclosed an opinion
My lord.
of the AG?
Huh?
Why you enclose an opinion of
No,
the AG?
because that was because essential, why? Because it's as per provisional law, it can be. I have seen.
No, how is it privy to you?
No, it is, that opinion also says
That
that,
opinion may say anything, but this opinion is not given to you.
no, not.
How have you been privy to it? Who has given it to you?
This, because I'm a cattle miller.
How?
Huh?
How are you entitled to an opinion given to the,
In that case, miller, that may not be taken into.
what do you mean that may not be here? File it in court.
But it is as per provision of law, it said.
Under what provision of law?
Uh,
Under what provision of law?
article. Read. But this is during coercion. But I've been punished
By whom?
by my client, but it is by but that is just
This opinion is not addressed to you or your client.
might have gone by through RTI or something, I don't know.
This is addressed to the joint secretary. How can the joint opinion address to the joint secretary?
That part.
I don't know how your client has acquired or whatever he has acquired is one thing. But how could you have, as a counsel, you could have
No, I was thinking,
enclosed?
because they have taken, because of course, that party, I have to look into what for this.
Huh?
Because as per provision of law, I think it cannot be, of course, that part is there, Miller, it is not furnished to the.
You are not entitled to. He is a constitutional authority.
No, that is,
How could this affidavit have been filed enclosing the opinion of the advocate?
I should file an affidavit not to be did as that is.
And the government is not objecting to it, Mr. Talukdar?
There is possibly no scope after the rejoinder, only we can orally submit it.
Even that oral submission is not here. I was surprised to find the opinion of an advocate general of the state enclosed in a reply affidavit filed by the petition.
I was not I had not started that. Zero.
Mr. Borua, you have to be careful.
Well,
You have to be a little more careful.
very sorry for that. There's apology and this, that may not be treated. If it, I'll file affidavit.
Where is that letter of 9/8/2016?
9/8/2016, Miller. And that is annexure 22, Miller, page 126 to 127. Right. 27 is vernacular and research on 26. The basis of that judgment was pronounced, my lord, on 12/2/2016.
Under the LA cases, you are not given the compensation.
Not yet.
He filed objection. Then he was offered alternative plot of land.
Why did you file objection?
He was not willing to part it, but that section 4/6 notices were issued.
Now, what has happened to the alternative plot of land?
In fact, at one point of time, it was
It is-
certain that 32 bighas of land somewhere will be allotted to him. But after this honorable court's order, my lord, a 4-member committee was constituted by the deputy commissioner. And they assessed the value of the land which were acquired and the well alternative plot of land. Then they came to the conclusion that 21 bighas will suffice. That was at that stage, my lord, it remained at that stage only.
Where is the finding of the report?
Page, my lord, that is
1-man committee is 135.
135 started, my lord.
Where is the order of the court constituting the committee?
No, there's an order of the court for constitution of the committee. Because of the order of the court, the committee was constituted by the deputy committee.
What page is that?
135, my lord.
135.
135.
135, NHR
It's a
25,
4-member committee.
my
Yes,
lord. They have, as per value, they have reduced the my area. That was last finding 137, my lord.
Now, pursuant to this, what happened?
Uh,
Pursuant to this
No,
order,
no action has been taken, my lord, till that. Then ultimate letter your lordship will get it. 10/12/2012, 22, my lord. Annexure 32, 150. Here again they have reduced. Lordship will get it. 10/1/2022. First it is written so ADC has sought information from circle officer in term that the circle officer has here written to the additional deputy commissioner by letter 10/1/2022, annexure 32, page 150, my lord. Here regarding settlement of this. In applying to subject cited with due honor, I'd like to inform that they regard land settlement pertaining to government measuring 21 bighas, Kolkata, 18 to let's so and so area North Guwahati Circle 15 bigha land in DAG number 305 is available. And said plot of land is water land and said 15 bighas land is not used so far. Therefore, said plot of land measuring 15 bighas of village Numoli Jala can be allotted in favor of Adinath and the petitioner, my lord. That was the last. Then the Lordship will get
This is after the report.
after the report. Then 24-22 again, it is additional Deputy Commissioner had written letter. That is annexed 33, my lord, 152 to the circle officer. With reference to subject cited above report by under reference regarding availability land of 15 bigha covered by DAG number 305 of so village in favor of the Adinath and Sodidis petitioner. In the above context, it is seen that land measuring 100 bigha was recently allotted to health department also and such other government institution in DAG number 305 village so. In this, I am direct to request to submit detailed report once again regarding the availability of the land 15 bigha covered by DAG number so. This is for kind information. This is the letter now. Now, thereafter, no progress has been on, nothing, my lord.
And the TC has filed an affidavit saying
Yes.
there is no land.
Saying there is
No
no
land.
government.
On what basis? There is no vacant government land.
There is no.
No vacant land. Only one line is written, my lord.
On what basis? They have to give some report or something. The circle officer has already identified.
घटना है, deny करती है। I don't know from where this has been taken, because the records are with me.
So
The
what does the
record
report-
also doesn't contain anything.
Huh?
It doesn't contain anything.
What do you mean anything?
Any report or something that there is no government land or DC cannot have the personal knowledge of that.
I heard learned counsel for the parties. And this petition is filed by the petitioner. Praying for a direction for allotment of 32 bighas of land covered by DAG number 154 of village Numoli Jala to be allotted in favor of the petitioner. The writ petitioner, the company having its registered office at Fancy Bazaar, Guwahati, and is represented by the petitioner number 3 as a director. So the petitioner is engaged in the business of construction and setting up and usage of agricultural storage marketing by constructing cold storage, ice plant, food processing plant, and other connected relevant sheds and structures. In view of the acute shortage of cold storage space in the entire Northeast, leading to wastage of a lot of valuable foodstuff, the petitioner company purchased 2 plots of land measuring about 4 bighas each on the national highway. These plots of 4 bighas of land were purchased pursuant to execution of proper safety. The petitioner company was also accorded the status of a small scale industrial unit. In connection with the project of setting up of cold storage and food park. The petitioner undertook investment, huge investment amounting to more than 1 crore for setting up these cold storage and the sale. stock. While thus situated, petitioners came to be aware of a declaration made by the government of Assam, right, RLA 74/2003/21 dated 2009/2023, issued by the Deputy Secretary, Government of Assam, Revenue Department in LA case number 3 of 2003, wherein land measuring 98 acres, 3 kotas, 17 lachas would be taken by the government. Stop. Petitioners realized that their plots of land measuring 8 acres were also, which was to be developed into food park projects, were also included in the said land, which is being projected by the government for acquisition for construction of approach road to the stadium for national games. So, the petitioner thereafter approached the Deputy Commission with their representations. Since their representations were not disposed of, the petitioners approached this court by filing WPC number 1017 of 2003. Stop. Pursuant to the orders of the court, the revenue officials communicated after,
That
sorry?
order, it was mentioned Miller, alternative land can be put.
Sorry,
That order represented disposal, that alternative land can be produced. The order is there.
where is that order?
That 21/2024,
Page number?
page 66 Miller. That will be important for me. Yeah. Page 66 Miller, Lord, you got it?
Yes.
That is last line here. In the process of disposal of the prevention, so filed by the petitioner, the government authority shall consider it permissible under the law for allotment of alternative plot of land to
While,
be in
while
commercial
disposing
highway.
of the petition,
That was the
this
one
court
observation.
directed
That is why it is important.
that if permissible under law, the authorities will explore the possibility of allotment of alternative plot of land to the petitioner in a commercially viable location. After several efforts being made by the petitioner, the Revenue Department identified a plot of land which was about 32 acres. Under tag number 1554. Of village Tumuli Jola, Muza, Sila Sundari Gupa, the North Party Revenue Circle. For identifying the same to be an alternative plot of land. the writ petitioner. Then you came before the court again.
Yes, I came again.
Where is that order?
That Miller.
One fifty-one.
That order is 130. Annexure 24 Miller.
Since the land as required to be allotted to the writ petitioner was not given, nor any compensation was given to the petitioner, he approached his court again by filing WPC number 6745 of 2014. This writ petition was disposed of with a direction to the Deputy Commissioner Kamrup, Amingam, take a final decision of the proposal for allotment of land of 32 bighas to the petitioners as an alternative plot of land in lieu of 5 bighas, 4 kotas, 2.5 leches of land of the writ petitioners which are already occupied in the year 2003. The said decision was directed to be taken by the Deputy Commissioner within a period of 3 months from the date of the order. Stop. Pursuant to the directions of this court passed in WPC so and so, a committee of 4 members was constituted by the government to examine the matter in connection with allotment and settlement of proposal of the government land in favor of the writ petition. So, the committee examined the entire committee constituted, examined this matter, and finally arrived at the conclusion that the petitioner is entitled to get 11 bighas, 1 quota of land as alternate land in North Guwahati Revenue Circle. Sorry, what was the finding here?
Here 20 this one,
21 big.
21 bighas, 4 quota,
21 bighas,
8.2
sorry, not 11, 21 bighas,
4 quota,
04 quota, 8.21
let's say,
letters,
8.2 less,
8.2 letters.
Miller.
Of
Village,
land at village Numoli Jola under North Guwahati Revenue Circle in the district of Kam. Stop. Pursuant to this order, several communications were issued between the Deputy Commissioner Office and the Department of Revenue for allotment of this alternative land. to the writ petition. There are communications available in the pleadings which reflect that the circle officer
Okay, that's okay.
has also issued communication to the additional Deputy Commissioner Kamrup Land Settlement Division indicating the availability of 21 bighas of land for being allotted. So, since no further steps were undertaken, the petition during pursuant to issuance of notice, the Deputy Commissioner Kamrup. Is it Kamrup Metro or Kamrup? Kamrup.
I mean, it is Kamrup.
Whose editor is respondent number 6 has filed an affidavit
Yeah, family is
before this court, whereas there are 4. There is an impairment. There is no vacant land for allotment of 32 bighas of land to the petition. So, however, in respect of the available 21 bighas of land, in respect of 21 odd bighas of land stated to be available, for which as is evident from the communications issued by the circle officer, there is no averment in the affidavit as to whether such land is available, and if so, why the same has not been allotted to the petition. So, learned government advocate is also unable to apprise the court as is not posted with the required instruction. Could we record that the records do not reveal
They, at least these records, whatever.
the
is
records
transmitted.
which are available the government advocate also does not reflect regarding the availability slash non-availability of land,
Government.
proposed land of 21 acres to the writ petition. So, under such circumstances, this court now directs the Deputy Commissioner Kamrup to file an additional affidavit in support of the averment made in the affidavit dated what is the date of the affidavit?
The affidavit will not control.
And then
1/7/2020.
1/7/2023.
1/7/2023. You write additional affidavit clarifying the took place before this court as to the availability of land as have been decided by the committee of 4 members in their report dated so and as found to be available by the circle of in the communication forwarded to the
24.
additional DC dated 24th of May 2022.
But here they have an M. District M there, I think, Kamrup M.
That's what we don't know.
But
But
they-
in
they-
respondent
But
6
there,
is,
there it is clearly mentioned M,
no, in your writ petition, it is respondent 6 is Kamrup.
Kamrup. But here, that land is Kamrup there, the questioning. But
So we
M-
are directing the Deputy Commissioner Kamrup.
yes.
This affidavit be placed on record within a period of 3 weeks from today. This affidavit must contain the steps taken by the DC pursuant to the report of the 4-member committee dated so and so in respect of allotment of the proposed land in respect of the petitioner. List after 3 weeks. Copy of this order be marked to the office of the learned senior government advocate, Mr. Vijay Talukar, for onward communication to the district.
That my lord, sorry, that may not be, or I should have filed affidavit. Should that affidavit apply?
That you have already filed.
No, that
Ordinarily, we
may
would have
not-
directed you to withdraw this affidavit.
Yes, and that may be, I may be allowed.
You may
to-
file an application before the registry for withdrawal. We don't need to record it. File it.
My lord, no problem.
My pleasure.
Yeah.
This petition is in fact, Lordship, for non-payment of compensation of my land, for my land, which has been used by the Water Resource Department for constructing a dike, the Blue Dot Protection Dike. Now, Lordship, since 1963, as the respondent number 2 has said, this has been requisitioned And they also say in their contradictory evidence, affidavit, that the lands were not used, etc., etc. But a joint survey, the deputy commissioner and the state made a joint survey with the water resource department, summarily lordship, and they found that my land had been used and it is still under use. At the time of, it was detected at the time of, by the petitioner, that his land has been used at the time of
When was it requisition?
requisition. As per, we do not know lordship, because one plot of land and in patta number 15, tag number 9, that was purchased after the purported requisition. Requisition was not formally made lordship, to my knowledge. But at the time of upgradation in 2012-13, lordship, when it came to knowledge of the petitioner that the land had been used, that has been clearly admitted by the deputy commissioner and in their affidavit, and the deputy commissioner's affidavit is lordship clearly in support of the or corroborating the petitioner's petition. But water resource department is also not denying, so far the joint survey is concerned, so far non-payment of compensation is concerned, to the petitioner. In other cases, lordship, they have paid compensation according to them. In my case, it is the clear position from the affidavit of the respondent number 2 water resource department that I was not paid for the land used by them, but not acquisition. There is no formal notification of requisition also issued to me. The respondents could not provide those except making a statement, those documents except making statements in their affidavit.
Yes.
Now, lordship, in this connection, lordship,
What is your prayer before the court?
my prayer is, lordship, direction to make compensation by making necessary acquisition or according to their process. I would like to,
Land has already already under their process, under their possession.
it is under their possession, lordship,
Yes.
because the dike is there. It is the Dibrugarh Town Protection Dike, lordship. But I would like to take your lordship to Annexure 8 of my at page 40, lordship, wherein it is categorically mentioned in this petition, lordship, letter by the deputy commissioner.
Paragraph? Para?
Para, lordship, it is
So you are referring
the-
to which para or page?
page 40, lordship,
40.
Annexure 8.
Yes.
Lordship, it is a submission of verification report, lordship, to the deputy commissioner by the circle officer. The deputy commissioner, the circle officer has reported that my land had been used, firstly, lordship. And thereafter, lordship, in the same annexure, lordship may kindly turn to page 41, where the trace map is given, lordship. Lordship will find at the middle of the trace map, dug number 8 is there.
Yes.
So this portion, the black mark portion, lordship, is the dike after upgradation. And in the 9, lordship, dug number 9, above that, lordship, on the north side, a little bit, which is about
So
Lord-
8 and 9, 8 and 9. duck
8 and
numbers
9,
are-
lordship. 8 is the main dug where my patta land has been taken to the extent of, lordship, 2 bigha 9 lessers and 16.5 lessers in dug number 9, only 16.9 lessers. So it comes to total 2 bigha 1 katha 5.5 lessers. This is the land, and thereafter, lordship, the circle officer's report in reply to, lordship, the annexure 8 Lordship may kindly turn to page 42. The translated copy, Lordship, wherein it is clear that it is surveyed that the present DTP dike falls on the land measuring 10 lesser of Dag number 3, 4 katha in 3, and in Dag number 4, 2 kathas, 2 lessers of Dag number 5, and 2 bigha 9 lessers of Dag number 8, and 16.5 lessers of Dag number 9. This is the report, Lordship, that those lands have been used. So far, the other parties concerned, they have paid the compensation as per their affidavit, Lordship.
Other part means
Other means, Lordship,
Other
in,
Dag number.
in other Dag numbers belonging to some other person. Those are 3, 4, 5, Lordship.
so in your case, why was it not compensated?
That is what is the reason, Lordship, not known to the, but the petitioner has been approaching.
What
And-
is the stand of the department?
Stand of the department is that lastly, the Water Resource Department has stated that those have not been used. But the joint survey, it is the admitted position, Lordship may kindly turn to Annexure 13, Lordship. At page 61 of the petition, Lordship.
Yes.
So the amount paid has been reflected at page 61, Lordship. So far 4 is concerned, Dag number 4 is concerned, Lordship, 21,30,000. And for Dag number 6, Lordship, 5 lakhs such and such. And for 31, those have not been mentioned. And so far my ducks are concerned, Lordship, the petitioner's ducks are at last of the table. Dag number 8, Sitha not received, Sitha not received. So far this part is concerned. And there is a, Lordship, after the joint survey, there is a letter from the Deputy Commissioner to the Executive Engineer, Water Resource Department, Lordship, Annexure 12. At page 59, Lordship. This is what is the basis, Lordship, where I would like to take your Lordship to page 60, Lordship. Last paragraph, Lordship, may kindly turn to. Hence, and just the concluding part, Lordship, to save time. Lordship, hence, from the above, it is clarified that land of Dag number 3 measuring such and such, Dag number 4 land measuring such and such, and Dag number 5 land measuring such and such, Dag number 6 land measuring such and such, Dag number 8 land measuring 2 bigha 9 lessas, and land measuring, in Dag number 9 land measuring 0 bigha 0 katha 16.5 lessa in the actual position of the dike, for which the acquisition proposal has been submitted. The proposal has been, dear Lordship, upon receipt of the confirmation from your end for initiating land acquisition through direct purchase by your negotiated settlement. So therefore, Your Honor, one thing is clear, that either by acquisition or by direct purchase system. There is a committee of the before the Deputy Commissioner that they have got one land purchase,
What is para 6?
Lordship.
Para 6,
There are 6,
page number 60.
60, Lordship. In case of Dag number 8 and 9, it was reported that the land was requisition. That is what is, dear Lordship, there is no such communication or notification to that effect known to the petitioner, Lordship. In 62, 63, but the said requisition,
8 and 9 belongs to you.
Lordship, these are the two ducts, only two ducts. Patta number is also 8, so far duct number 8 is concerned, but for duct number 9, Lordship, patta number is 15.
Yes.
Lordship, position of the dike, since the present position of the dike passes through duct number 8 and 9 along with duct number mentioned above, along with means Lordship 3, 4, 6, etc. For which, according to the water
Now,
resource,
what directions do you want from the court?
Lordship, my prayer is that the respondent number 2, mainly the water resource department, may be directed to make arrangement for giving some time, Lordship, to make arrangement for payment of compensation of this as per the actual report of the survey. But there is a Lordship, I would like to take your Lordship to Annexure 16 of the respondent affidavit of the respondent number 3, Lordship, at page serial 128, Lordship. That is what is the government's proposal, Lordship. Yet the water resource department is not inclined to actually comply with those.
Yes.
Lordship, this is the government revenue department, Lordship, DMLR report department, wherein the secretary to the joint secretary to the government of Assam had written a letter to the deputy commissioner. Lordship, I would like to just read it out. With reference to the above, I am directed to inform you that instead of initiating fresh proceeding for acquisition, this can be taken into account, Lordship, fresh proceeding for acquisition of land, which is already the part of the dike that has been admitted by the government. The amount of compensation can be worked out under land acquisition through direct purchase by way of negotiated settlement. This can also be done, Lordship. Thereafter, the alternative processes have also been laid down in this letter. Further, the compensation as computed above can be paid to the landowner if he consents to relinquish the land and suitable correction can be made in the land records to avoid future litigation. That is what also anticipated by the government, Lordship. You are therefore requested to communicate with water resource department. So the deputy commissioner was directed to communicate with the water resource department whether cost of land acquisition will be borne by them or not. If yes, whether the compensation can be assessed as per direct purchase policy. In case the landowner is not willing to relinquish the land acquisition proceedings may be initiated. That means government is bent upon to the acquisition process. So to expedite the compensation, perhaps, Lordship, the direct purchase negotiated settlement was advised, Lordship, in this letter.
Then what happened?
Then what happened, Lordship? The water resource has not been complying with this. That is what is the
No, but-
reason why, Lordship.
Whether it was communicated to the water resource. This
Yes,
proposal,
Lordship. Water resource department is taking this or that pretext to avoid it.
no, this letter is to the deputy commissioner.
Yes, Lordship. That is what I have already.
Yes. So this proposal, was it conveyed to the water resources department
Yes, Lordship.
by any communication?
Yes, Lordship. 13, Lordship. I had already referred to this letter, Lordship, Annexure 13, at page 61 of the petition. This is what was communicated, Lordship. I'm sorry, Lordship, 59. Page 59, Annexure 12,
59
Lordship.
of the writ petition.
No, yes, Lordship. 59 of the writ petition, the executive engineer water resource department was communicated by the, about that letter, Lordship, issued by the government. Page 60, Lordship, last para that I read it out. I'm last para, Lordship. Hence from the above. Lordship pointed out this para 6, so it is from
No, no, that is okay, but this direct purchase suggestion or proposal, was it communicated?
no, Lordship. Water Resource Department is silent on this point. So I had to come before your Lordship.
Yes, what do you say, water resources?
Lordship, as per my instructions, Lordship, which I have received, Lordship, a meeting was communicated on 16/5/24 in the office chamber of the ADC Dibrugarh, where it was decided that a joint survey will be conducted by the team of Director of Land Record, resurvey, not joint survey, resurvey. And accordingly, resurvey was being done. This is the internal communication. Which was,
What is the result?
no, the survey result is awaited, Lordship. That has been conducted by the team of Director of Land Records, Lordship.
Joint survey by whom?
No, resurvey, not joint.
Resurvey
Resurvey.
of the entire land.
Entire
or
dike.
only these two tag numbers?
No, on entire dike, Lordship. Entire dike. And they have conducted the resurvey, Lordship, and the report is awaited, Lordship.
When is it likely to be available?
Lordship, that Director of Staff of Land, Director of Land Records,
Who is appearing for land record?
Land record is not a party, Lordship.
You share a copy of the communication to your colleague.
Lordship,
Ask her to obtain the instruction.
Lordship.
My instruction is that, Lordship, that survey has also been completed, but the report has not been submitted,
That is what he said. It is completed, the report is not available.
not available. Lordship, if the report is submitted before your Lordship, then it will be clear, Lordship.
That's right. Heard, on submission made by the company. That the land for which the, what do you call it? Dike trench.
DTP dike,
DPP dike trench. DYK dike trench.
DTP Dike Trench 1.
TRANCHE -1 in the district of Dibrugarh, passing over the land inter alia belonging to that of the writ petition, a joint survey was conducted. Is it a survey, joint survey? Resurvey. Resurvey has been conducted by the Directorate of Land Records. Stop. It is submitted that the survey has been completed, but the report has not yet been placed to the court. It is not available. So, Mr. R.M. Das, Learned Standing Counsel to the Water Resources Department, has submitted before the court on the basis of a communication that the report of the resurvey is not available in court. It has not been furnished to him. So, he, however, has no instruction as to when the report may be available, as the same is conducted by the Directorate of Land Records.
Land.
MSG Hazarika, learned government advocate, has been furnished with a copy of this communication by Mr. R.M. Das in court today, and she will obtain instructions as to when the report of the resurvey conducted by the Directorate of Land Records in respect of the said DTP dike trench number 1, item 1, will be available. Stop. A copy of the said report is available, be placed before the court on the next day. Depending on the outcome of the report, further orders as may be necessary will be passed by this court. Mr. L. Talukdar appears for the writ petition. Matter be listed. How much time?
if the time is, yes, Lordship.
Yes, after vacation, give us a date. Immediate. 19 July.
Lordship,
19 July, it's for 19 July,
19 July, sorry, Lordship, 19, oh, July, Lordship, oh, it's okay.
19.
Obliged.
Yes.
While last order dated 3/6/2024, Lordship, the Honorable Court wanted to know when will the election will be conducted in relation to the Lanka Regulated Marketing Committee, Lordship. So, Lordship, we have prepared a schedule, Lordship. On the 5th of September, Lordship, the elections will be held.
What is the prayer sought for in the writ petition?
Prayer, Lordship,
Already-
that was not there.
My lord, the prayer was to allow us to assume charge as chairman, which we were continuing to hold by virtue of this honorable court's order, because they had not given us extension under section 9. Therefore, my lord, on the last occasion, the honorable court, after perusing and hearing the submissions, was more inclined to
His
direct the
tenure is
respondent.
already over, Lordship. In fact, his extended tenure is also over, Lordship, as chairman.
So the honorable court wanted the respondents to come up with a timeline within which the election could be held.
The timeline is here now,
I have not been served with a copy.
and assuming he is what, he's the,
Chairman,
I was serving as the chairman.
ex-chairman,
so the tenure is of the entire committee.
Lordship.
Lordship, the first meeting was held on 1/10/2018.
No, tenure is for only the chairman of the committee.
All
The entire committee.
entire committee.
Entire committee.
Yes.
Now, according to you, if the committee's term is over,
Yes, Lordship.
who will run the,
Now the district
election.
agriculture officer run the committee as a ad hoc chairman.
The
The
district
district
agricultural
service.
officer, Nagaon, was running the committee as a ad hoc chairman, Lordship.
no, ad hoc chairman of what?
The Lanka
Lanka-
Regulated Marketing Committee, Lordship. So, Lordship, on the last
He runs as
occasion,
the director or
the chairman, Lordship,
Chairman.
as the chair?
by Rule 48, Lordship.
Yes,
The state
so
government
what
had the
the
power. So, Lordship,
rules-
are we going to say? 48, Lordship.
Rule or section?
Section 48.
Section, Lordship, sorry.
Section 48.
Page 62.
This is a general power.
Yes.
The state government may delegate by notification in the official gazette any of the powers conferred on it by or under this act to any of its officers or to the board or to its chairman or chief executive officer, Lord.
By which order?
My lord, at page 53 of the writ petition, the order is there.
Where is the term of the chairman of the committee?
Section 9, my lord. Section 9, clause 1.
Section 9.
Yes. Talks about the term of the market committee as being 3 years.
3 years.
Yes. And my lord, it also says that before the expiry of the term of the existing committee, 3 years prior to that, a notification has to come announcing the elections. And the process has to be covered so that there's a smooth transition from one committee to the other. Since they had not done it, they had, by way of exercising powers under section 48, decided to appoint an ad hoc chairman. My lord, my submission was that they were not empowered to do so under section 48, because they were not empowered to appoint the chairman under section 9. And in
22
fact,
from
as per section 9, clause 3, they were liable to give us an extension for another year till the term of fresh committee was not elected. That was precisely my prayer in this writ petition, my lord. Where it is state can do something that they are not empowered to do under that.
Lordship, may kindly peruse page 52 of the writ petition.
Lordship. 52.
52, Lordship. That is the first round of litigation, Lordship. And this is the second round of litigation.
52.
Lordship, 52.
It has become infractuous.
Lordship.
Why?
Because his extended tenure was over, Lordship.
Also, earlier under the litigation, they have
My lord,
this
I
petition was
was,
filed for.
since my term was about to expire, I had written to the department to allow me 1 more year's extension under section 9(3), which they did not respond to. And since my tenure was about to come to an end, I filed a writ petition before this honorable court. And the honorable court directed that status quo be maintained. And that order was extended from time to time. And on this day, my lord, when which the Learned Standing Council is showing, on that, in the absence of the Learned Council for a petitioner, based on the submission of the respondent, which to their understanding the term had expired.
You bring it on record, this schedule.
Yes.
You bring it on record.
Lordship.
You bring it on record.
Yes, yes.
Enabling
By
that.
filing an affidavit, Lordship, additional affidavit.
Bring it on record. File it within 1 week. 2 weeks.
2 weeks, Lordship.
2 weeks.
I have to fix a date, friends.
It is submitted. And Mr. Borua appears to the petitioner, submitted by Ms. R. Bora.
Lordship.
That and appearing for agriculture
Lordship.
department and Mr. N.J. Gogoi for
For
bargaining.
4 and 6.
That the schedule for the election for which committee?
Lanka Regulated Market Committee.
Huh?
Lanka Regulated Market
Lanka
Committee.
Regulated Market Committee has been announced and it is likely to commence from
July, 5th of July.
5th of July.
5th of July, Lordship. 5/7/2020.
5th of July. The preparation of electoral roll, etc., will commence from 5th of July, and the date of election has been shown to be 5/9/2024, and the results to be declared on 6/9/2024. So, let this information be brought on record by way of an affidavit filed by the competent authority. So, let this affidavit be filed within a period of
2 weeks.
2 weeks.
2
My
weeks.
lord, it's already there.
After
2 weeks to
vacation.
file an
After
affidavit.
vacation, Lordship.
No, my lord,
It will already.
it will be too late, my lord. They already have the schedule. They just have to put it on the affidavit.
Me filing the affidavit on dealing the election process. It will already.
I might have
Yes,
to
sir.
file any objections if necessary.
File it within 2 weeks, give them a copy.
Yes, Lordship.
Let the affidavit be filed within a period of weeks. That will be listed on 26 June.
Obliged.
Also obliged.
List accordingly.
Lordship, kindly produce order dated 9/4/24. By this order, it is directed to obtain the instruction.
Where is the APP not here? We'll take it up at 2 p.m. Taken up.
My lord, can it be some problem in the second half? Any date next week?
No, the APP is not available. We have to find out what is the status.
Or day after tomorrow. Today,
Next week.
next
Yes, sir.
Next week already.
oblige, my lord. Oblige, my lord.
Wait, please, Lord.
Yes.
But the petitioner before your lordship is the court officer of this registry, my lord. And the factual aspect of the whole matter is, my lord, that he was Very initially, he was appointed as a computer operator in the year 1996.
You are addressing the IA or the?
I'm starting with the writ petition, my lord, then I will take your lordship to the higher.
Yes.
My
Have
lord,
you served copies on the?
everything
Standing
was.
Council High Court?
Yes, yes. Mr. Gautam Boisse appears, my lord. I believe he will come, his junior is here.
Is reflect Standing Council High. Yes, yes.
Then, my lord, he joined as a computer operator in the way back in the year 1996. Then he was promoted to the post of LDA in the year 2007. Then he was appointed as a senior administrative assistant on 30 October 2013. Now, this post senior administrative assistant is now redesignated as senior judicial assistant. Same post was renamed as senior judicial assistant. What happened, my lord, in the year 2016, the registry issued a notice calling for options for the post of court officers from amongst the senior judicial assistants. I, being a senior judicial assistant, I applied. And I got appointed as a senior court officer in the year 2016, but with a rider, my lord. If your lordship can come to page, my lord, 16 of the writ petition, my lord.
Yes.
Page 16 of the writ petition is the advertisement by which I was called, the options were called for. In continuation to the registry's earlier notice that so-and-so options are further invited from the intending administrative officer, senior judicial assistant of this registry for filling up of one vacant post of court officer in the principal seat, but of the Guwahati High Court, Guwahati in the pay band of so-and-so, 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 plus other allowances admissible evidence, as admissible as per the rules. Then, my lord, the next page is the annexure 2 is the calling letters for these three persons. Has your lordship got it?
Yes.
I am at the serial number 3. These are the persons who were called for interview. Then in the next page is the appointment letter. Well, everything is fine in the appointment letter. Kindly see the last paragraph. Sri Zahirul Islam will maintain his seniority in his original cadre, that is the senior judicial assistant, and his further promotion will be considered on that basis. Due to these two lines in the appointment orders, my lord, I was never considered for any promotion from the post of court officer.
What is the next higher post?
From court officer, my feeder cadre, court officer is a feeder cadre for the post of assistant registrar.
From where do you say that?
My lord, if lordship takes up the High Court rules, my lord.
High Court rules.
And your lordship can see the IA also, that is there, the notification is there, my lord. In IA, lordship can see the notifications. My lord, administrative officer, judicial.
Page.
Notification is page, the original copy is page 12, my lord. A1, annexure A1. And if your lordship takes the High Court rules, there is a schedule. In that schedule, my lord, lordship can see, I can give the book to your lordship.
So you are referring to page 12.
Yes, and page 12. Kindly see the second table. Interview for the post of assistant registrar. Serial number, name and designation, Rajkumar Kolita, Hasna Begum, Brodhan 1000, Pradeep Sharma, Vidyut Vikas Goswami. These are the AOJ. And the AOJ and the court officer, both are of same rank, class 2C. Lordship can take 665 of that book, mail. Page 665. In the midst of the page, 665.
Yes.
Class 2C. Yes. Administrative officer, judicial, stamp reporter, court officer, protocol officer, assistant librarian, and serial system. I am the court officer. So, court officer and administrative officer, judicial, stamp reporter, they are the feeder cadre for the post of assistant registrar. If your lordship can see now the notice, then all are the administrative officer, judicial. And from this.
No. From where do you say under the rule what is the feeder cadre? Eastern register is 2A, isn't it?
Yes, 2A.
So what is the feeder cadre from 2A or 2A?
My lord, 2C is the feeder cadre for 2A. Because the next rank of administrative officer is assistant registrar. Then deputy registrar, then joint registrar. And then registrar establishment.
No, that's what I'm saying. Where do you, from which route do you say that feeder cadre is 2C? Is there any notification or?
My lord, this is the
This is the schedule.
yes, ma'am.
Now this schedule is under Rule 11.
Yes, ma'am.
So what does Rule 11 say?
Rule 11 is a part 3, page 648.
648.
48. Of the book, Miller. In the left side.
Yes.
Cadre and pay. The cadres of the different classes of service in the code, including the number and character of posts and the scale of pay attached to them, shall be those as set out in the Schedule 1. Schedule 1A, Schedule 1B, Schedule 1C. Only we are related to Schedule 1 only. The Honorable Chief Justice may from time to time leave unfilled or hold in events any vacant post. The registrar, deputy registrar, and assistant registrar. The post of registrar, when filled from service, will carry a special pay. This is not related to us. The post of registrar, when its incumbent is recruited from outside the cadre of the state judicial service, is not related to us. The post of the joint registrar, when the incumbent is recruited from, is not related to us. Other conditions of service of the registrar, including the grant of leave, no, it's not. The post of deputy registrar and assistant registrar, when filled up from the state judicial service, will carry a special pay. No, it's not. The conditions of service of deputy registrar in class 2 and class 2A, respectively, will ordinarily be regulated by the rules and orders applicable to members of the service to which they may belong. The Honorable Chief Justice will be competent authority to regulate the conditions of service under these service rules and relax the same in appropriate cases. And no matter, it's not written here, but this is the feeder cadre, as I am instructed, my lord. And that is why these all the persons which have been called for the interview is, my lord, the ratio is 1:5. There is one post. That is why 5 persons have been called. But all these persons are junior to me. Now, my lord.
Yes.
Now, my lord, kindly appreciate. This person was promoted to the post of court officer, which is a higher cadre post than that of the senior judicial assistant, carrying higher scale of pay. And this rider condition, special condition put forth in the appointment orders, put a clog on his service career since 2016. And this issue was raised in a recent case of this registry. The case is known as Nilud Sharma versus Safikur Rahman and others. The division bench of this court, Milord, have decided this, and kindly appreciate that I have annexed that judgment. If your lordship can come, that this rider that given is very common and very plain questions of service law. That when a person has been appointed after proper selection, after following a due process of selection in a higher cadre of pay in a higher grade, his inter-se seniority cannot be ordered to be maintained in the lower cadre. The Honorable Division Bench of this Honorable Court, my lord, has dealt with this matter extensively in the case of Nilud Sharma versus Safikur Rahman. It is page 24 of the writ petition. Of the writ petition, and I also have annexed that judgment. Page 24 is the judgment, my lord. And I will take straightway to your lordship to page 30.
7. Last paragraph. How we are similarly situated with Nehru Sharma's case. That is what I am going to show. And what is the findings of the Honorable Court as regard the last two lines of the appointment orders. If I take your lordship to paragraph 61, bottom of the page 37.
Yes.
The contents of promotion order number so and so dated 27/2017 is reproduced as below. The following judicial assistants are promoted and appointed in order of merit on ad hoc basis until further orders as senior judicial assistant in the principal seat of the Guwahati High Court, Guwahati, in the pay band of rupees so and so, with grade pay 9,100 per month, plus other allowances as admissible under the rules, with effect from the dates of their joining. Vice Shri Sahidul Haq, Tomizuddin Ahmed, Shri Tilak Kumar, Bhavesh Chandra Das, so and so, so and so, so and so, so and so, Manoj Kumar Goswami, all senior judicial assistant appointed as court master, court masters. Fourth line from the top, my lord. Shri Benjamin Nampui and Shri Niroj Sharma, both senior judicial assistant appointed as protocol officer, and Shri Zahirul Islam, this is me, senior judicial assistant appointed as court officer, subject to the condition that upon reversion of the said court masters, protocol officers, and court officer to the post of senior judicial assistant, they will be stand reverted in their original cadre of judicial court, original post of judicial assistant. After saying this, these persons were promoted to the post of SJA, senior judicial assistant. That means these persons have occupied the place, resulted vacancy that we have left after appointment as a court officer or protocol officer or court master. Am I clear to your lordship?
Not very clear.
Madam, I am explaining. Madam. This Bankim Sharma 1 to 16, my lord. These names, my lord.
That is okay. You show us. Firstly, you show us that what is the feeder cadre to the post that you are seeking promotion to, number one. Number two, you are relying on the judgment to show that the seniority directed to be maintained in the original cadre is violative of the judgment.
Yes.
Is that your submission?
My lord.
Right. You show us.
I'm saying, before that, my lord, we have to understand this paragraph. Kindly appreciate. Because this paragraph, the second paragraph is the result of the narration of this paragraph. I'm trying to explain in a simple language. This person 1 to 16, they were promoted to the post of senior judicial assistant from judicial assistant. With a rider that you have been promoted to as a senior judicial assistant, with a condition that if this aforesaid person, Tilak Kumar, Niroj Sharma, Zahirul Islam, if they do not come back to their original cadre, that is senior judicial assistant, that means Niroj Sharma, Zahirul Islam and others, they were promoted to different higher cadre like court officers, court masters and protocol officers. Because of their promotion, there are certain vacancies arose in the cadre of senior judicial assistant. These persons 1 to 16, they were promoted to this post that were left by Niroj Sharma, Zahirul Islam and all. So in their appointment letters, it was given that look, you are appointed provisionally. If your fellow above, they come back to this cadre, then you have to again go to the below mentioned cadres.
They will be reverted.
They will be reverted back to the judicial assistant. If Niroj Sharma, Zahirul Islam and other persons who were promoted, if they have to come back,
why will they come back?
Because same conditions were there in their application, their appointment order. When Niroj Sharma, Zahirul Islam and others were promoted, my lord, as court officer and
once you are promoted,
this is
different post. Where is the question of reversion unless there is
impunity? If there is a punishment, unless there is a punishment.
Some defect.
Yes, that is what the crux before the court.
Unless you say that these posts like court masters, court officers and others, notwithstanding their feeder cadre is this AOJ, they are posts with special responsibility and they are promoted. And if after rendering some service, if the concerned officer feels that he would like to go back to his parent post, then he gets rewarded. In other words, these posts to which these AOJs are promoted are not really feeder posts from where you'll get your higher promotion. Your feeder post will be measured with regard to your original post, which is AOJ.
Right, madam. One aspect perspective, it is correct. What I'm on is, madam, this rider condition given in the appointment order, appointment notification, that your original senior, inter seniority will be maintained in your original cadre, where from you have come.
Correct.
This is illegal.
Why?
This is illegal if I have to go back and you have filled up my resultant vacancy.
You don't have to go back. This post that you're currently holding under the rule is not a feeder category post to a higher post. Your feeder category remains with the post from where you had come.
No, my lord, the post of court officer, court master, protocol officer is a higher post than the post of senior judicial assistant.
Maybe a higher post, but for still higher promotion, your these posts, if they're not identified,
But division bench has said otherwise.
that is what we
Yes, I'm trying to bring to your notice.
bring it towards.
Yes, paragraph 62, next. The above two orders clearly show that the vacant post of SJA had occurred due to the promotion of SJAs as court master, protocol officer, and court officer, etc. The condition put in the above two orders, which states that upon reversion of the court master, protocol officer, and court officer to the post of SJA, would result in the new promotees being reverted to their original post of judicial assistant, has been done in routine manner. The same appears to have been put there specifically due to the post of court master being a different cadre than protocol officer and court officer. While the post of court master is class 2 DD post equivalent to assistant protocol officer, the post of court officer and protocol officer are class 2 C post. That is the promotional post of court master in terms of Rule 7.5 of the 1967 rules. The rider condition put in the above two orders dated so-and-so does not take away the fact that the subsequent promotions made to the cadre post of SJA left vacant by promotion of SJAs to a higher post are regular promotions. As such, the bar on the appellant's appointment as regular PO due to the rider cannot continue when his post of SJA had been filled up on 27/2017. Meaning, dear my lord, if I cut short the whole paragraph, that means when the resultant vacancy, while I was promoted as a court officer or protocol officer, that resultant vacancy you have filled up on 20 July 2017, then this rider condition that my inter-se seniority will be maintained in the senior judicial assistant, that cannot continue. Therefore, on 20 July 2017, I was eligible for consideration to the post of
But
assistant
for
registrar.
that, you'll have to show that what is the feeder category,
For assistant registrar.
whatever promotion you are asking now.
My lord, my name may be included in the post for the interview list for the post of assistant registrar, because administrative officer, judicial, and court officer are of the same category, same cadre, class 2 C. Class 2C, protocol officer, court officer, AOJ, assistant administrative officer, judicial, all are from the same cadre. And these cadres, this post under the class 2C cadre is the feeder cadre for the post of assistant registrar. My senior friend will clarify from the High Court side. Otherwise, this person would not have called for the interview to the post of assistant registrar. My lord, this judgments of the division bench have categorically stated that from 27/2017, this condition cannot continue because the resultant vacancy we left that has been filled up.
No, these judgments says that once your vacant post in the feeder in the lower cadre is filled up, your promotion to the higher cadre
Is confirmed.
is confirmed.
My lord.
The rider will not be a
My lord will not be continued.
Correct.
Right.
But how do you now correlate that this particular post,
Court officer,
and the next higher post
is assistant registrar.
the court officer is one of the feeder category?
Yes, my lord. That is what I am trying to show from the schedule. serial in class 2C, it hails, my lord, in class page 665. In class 2C, there are 6 posts, my lord. Assistant Administrative Officer, Judicial, Stamp Reporter, Court Officer, Protocol Officer, Assistant Librarian, and Senior System Officer. These are the posts in class 2C, which are the feeder cadre for the Assistant Registrar. Well, had it not been a feeder cadre, though this notification would not have included these 5 names of Administrative Officer, Judicial. Well, the examination is from tomorrow, not from on tomorrow. 1 day for oral interview. Well, I got this post of the court officer in the year 2016. And according to the division bench judgment, it has become permanent on 20 July 2017. So already 35 persons have been promoted to the post of assistant registrar from this cadre. I have annexed the RTA reply given by the registrar. I'm retiring next year, my lord. In the year, in the first 3 months, almost 1.5 years left of my service career. I would get nothing after rendering a relentless service of court officer.
It doesn't deal with the sources of promotion.
And the rules, my lord, there are.
Yeah, show us the rules.
And in rules, my lord, it has been pros and cons of these rules has been discussed in this judgment in a very extensive manner. But the rules is there are many gaps, my lord. There are many gray areas that I cannot help.
Show us that this is the feeder category. You'll have to show us that this is the feeder category. Where is the provision for promotion?
To the post of assistant registrar.
Whatever post, what is the rule, prescription of the rules for promotion?
Well, the rules doesn't say anything as such that how it will be promoted. There are maybe some committee's resolution. The whole thing have been discussed in this judgment, division bench judgment. that there are many gray areas, how to promote a
You
person.
belong to which category?
I'm court officer class 2C.
Yes, Mr. Busu.
My lord, kindly consider the last order, first in read petition, my lord, that is the order of 30th May.
Yes.
My lord, on interim care, my lord, the notice was issued, my lord. And the next date has been fixed on 26/6, my lord. And my lord, by way of this IA, in the disguise, my lord, he wants to obtain some stay order, my lord. And
I'm not asking for any stay orders.
My lord, he wants to appear to participate in the interview, my lord. Now, kindly consider, my lord, one thing that will amount to allowing the way read petition, my lord.
No, but supposing he has a claim. Supposing after decision of the matter he has a claim. Then what do? You hold a review DPC, review interview
There will be third party right created then.
for the one post.
My lord.
There's only one post.
Only one post.
One post.
So if it is filled up, then that person's appointment will be taken.
My
and
lord,
will be held.
I don't have any instruction, my lord, even in the morning.
Then you don't hold the interview or you hold it after 26.
Well, I'm also not praying for a held up of the interview. I said include my name also.
Yes, my lord. That can be done.
Or you permit him to appear
Yes.
subject to outcome.
Subject to outcome,
Subject to
yes.
outcome, yeah.
Huh?
That
The
can,
result will be kept in seal cover of all the
Permit him to appear.
that can be.
let him
I
allow.
leave it to your lordship, man.
So
But
tell
the,
me, you are the standing counsel of the High Court, you tell us.
but the facts remain, my lord. He approached the court at the last time.
Whatever it may be, but
My lord,
you
my
tell
lord,
us, you
my
tell
lord.
us what is the prescription of the rules?
My lord.
What is the rules?
Yes, my lord. That I'll place, my
When will you place? He is asking
lord. Without inspection, my lord.
my lord,
at 2 p.m. We'll take it up at 2 p.m. Come back at 2 with your instruction.
my lord will appreciate. This notification was issued on 7 June evening. We filed the IA yesterday.
What is the promotion now?
Yesterday, yesterday.
Hasten register. If
Yeah.
you come to page 640, you have the rules.
Yes.
My lord.
Serial number 3.
Yes. Yes.
Promotion.
This is the feeder cadre, my lord. I'm so obliged to your lordship, my lord. This is the feeder cadre. This is the mention. here.
Class 2C.
Class
So
2C.
court officer is a
Feeder cadre.
class 2C cadre. Defines him as a feeder cadre.
Yes, my lord. Only one thing, my lord. This judgment, whether is applicable to his case or
No,
not.
it doesn't apply.
No, my lord.
It doesn't apply.
My lord.
The judgment is only with the finding that once a post is filled up,
My lord.
there is no scope for the officer to come back. So therefore, that rider that the seniority will be maintained in the feeder cadre will not be a bar for confirmation in the higher post. It is the ratio is only to that extent.
And
It
his
doesn't talk
entry,
about, it doesn't talk about any.
exactly, my lord.
feeder
And
cadre.
his entry in the year 96 as computer operator.
We don't know. But
That's what
as on
he
date-
has stated.
As on date, he holds a post which falls under
2C.
2C. And 2C is one of the sources for promotion to
To
the.
the eastern district.
So either you say that no subsequent notifications or some circulars are there, doesn't, which says that he does not follow.
My lord, in that case, I will come back at 2.
Yes. Notifications at 2 p.m.
My lord.
Get your instruction.
My lord.
Well, inclusion of his name in the interview will not be
He
creating any
approached the
trouble.
court at
Check
the.
to there's being a provision under the rules. You can't just come out and say that nothing is going to, heavens are not going to fall if my name is included. Whether your rules permit you to do so.
My lord, as your lordship has shown us that the rule 3 says the feeder cadre.
Let him come back at 2, get his
My lord,
instructions,
my
we'll
lord,
see.
my lord.
At the belated stage, he approached.
No, it's not belated. I'm so sorry, my lord. How can it be belated, my lord?
Yes, sir.
Or you defer it till 26,
Yes.
or 27, whatever date you want.
Let me take the instruction and come back. Oblige them.
Notification was issued on the 7th June in the evening. I approached yesterday, my lord. Saturday, Sunday, I have to.
No, when was the order passed in the writ petition?
30th May, ma'am.
Then? Why do you say?
No, on 30th May, kindly see the last line of the order.
Huh.
Kindly see the last line. The interim order has been kept vacant, kept open.
Correct.
Honorable court, honorable judge was saying orally, which is not reflected, that you can approach us with an IA if immediately something is going to happen. That is kept open. That is
So
why
on
the IA.
that day, the interviews were not notified.
No, not at all. How come that is what I'm saying.
Very well, at 2 p.m.
That is on 20th May, that order. And it is 7th June when it was notified.
Yes, yes, at 2 p.m.
Yes,
Take it.
I'm obliged.
Okay.
For hearing item 10, 30.
May I please, Lordship,
What is your name?
Miss R. Dupley?
And in the list of councils shown in the cause list,
Yes,
none of the councils are available.
no, sir.
Why? Where have they gone?
Sir, my senior counsel is having some fever and
Your senior council, who is your senior council?
Dr. A. Toti.
Yes, okay. But besides that, there are other 4 councils.
Yes, sir, and one of the senior counsel went to Tezpur for some other.
So you read the brief and you argue the matter we are taking up on Thursday.
Okay, sure, sir.
You read it. Yes, anything to submit?
No, Lordship.
Pleadings complete.
Pleadings complete.
We'll take it up on Thursday.
Okay, sure, sir.
Let her get prepared.
Much okay.
2017 matters.
Yes, sir.
It is submitted on behalf of the petitioners that the arguing counsels are not available in court. Counsel is permitted to take necessary steps in the matter for due representation. Matter be listed on what is that date? 13.
Yes.
13th of June.
This Thursday, Lordship.
Yes, this Thursday. You read.
Lordship, please
You
kindly,
start reading from now, from 2 o'clock.
kindly list of the matter next week.
No, this Thursday. This Thursday. You are there, you read the brief, tell us what is it?
Sure, sir.
Yes. List on 13th. Mr. B. Chaudhary and Mr. H. Bora appears for the response. Yes. 13th.
Sure.
It's a long pending matter, otherwise become infractuous, my lord.
Infractuous.
In other way, my lord, because
It has become infractuous.
Yes.
Okay. Learned councils, the bar submit that this writ petitions have become infractuous. Accordingly, the same stands dismissed. Interim orders, if any, stand vacated.
interconnected matter, 14.
14-15, yes. Mr. S. Summary appears for the respondent. MS,
Kalyani De, Lordship.
MSK Day appears for the writ petition. 14 and 15.
14 and
This
One.
starting from 644, method procedure of recruitment. The post of court master may be filled up by selection.
640.
644, my lord.
Is a method, yes.
Method procedure of recruitment. The post of court master may be filled up by selection on the basis of merit cum seniority from amongst the senior judicial assistant working at the principal seat of the Guwahati High Court, having 8 years of experience as SJ or both combined. Preference may be given to SJ having degree in law from any recognized university. Nature of appointment. The appointment to the post of court master will be temporary and subject to review every year. Selection and appointment of an employee as court master will not be treated as his her promotion status, gazetted promotion. An employee from SJ, which he is holding that post,
No, no, I am court officer.
Court officer, yes. An employee from the SJ cadre holding the post of court master will be considered for promotion as administrative officer judicial as per her own seniority in the rank of SJ. The J holding the post of court master will be considered for promotion to the post of administrative officer judicial. On the basis of
This is court
This is
master.
court master, I am
Court
court officer.
He is a court officer.
it is different.
Court master is court class 2 DD. Our court officer is class 2 C.
C. Yes.
In page 665, Miller. Class 2 C is the administrative officer, judicial, stamp reporter, court officer, protocol officer, assistant library, senior system officer. Then below that, Miller, ministerial establishment, non-gazetted, class, sorry, above that, class 2 DD, court master. My court officer. That is a.
And regarding court officer, my lord, this is the notification.
Here, here.
No, my lord, I take it here. The following sub-rule is added to sub-rule 4 under Rule 7 Gazetted Officer. Sub-rule 4, the post of court officer in the principal seat of the Guwahati High Court and the Kohima bench shall be filled up by the calling option from administrative officer judicial and the senior judicial assistant. The persons so appointed in the post of court officer shall maintain their respective seniority.
But this is for court officer.
Court officer, yes, madam. Oh, well, this is also not relevant, madam.
He's seeking his appointment to the post of assistant registrar.
Assistant registrar.
So, what do you say about clause rule 3?
Rule
Rule
7.3. Rule
7.3, madam. That is holding the field. The assistant registrar shall be appointed from among the state judicial officer grade 3 or by promotion from among the gazetted officer of the High Court. Service belong to class 2B, class 2C or class 2D or from among advocates or not less than 5 years continuous practice at the bar.
I mean,
Now, who are the gazetted officers?
these are all these cadets, class 2B, class 2C, these are all gazetted officers.
Gazetted officer starts from Rule 7, madam.
So, which are the posts?
Well, these are the posts mentioned against these classes. That is in that lordship can see at the schedule. Class 2AA in 664 last category, class 2 AA, then class 2B, class 2C. These are the and class 2D.
Yes, what do you say?
My lord, at this stage, my lord, without the instruction, my lord. Only thing is, my lord, let him appear, my lord, subject to outcome.
We heard in the IA 1769. Heard Mr. H. Amohal, the Commissioner, Mr. Busho, standing counsel appearing in the Guwahati High Court. Respondents 2 and 3, and government advocate appearing for the state officer. So, the present writ petitioner, he is employed as a court officer in the Guwahati High Court. he was he joined his service in the ministry as a computer operator on 14/8/1996. Subsequently, he was promoted to the post of LDA on 2006 and then and further promoted to the post of senior administrative assistant. So this post was later re-designated as senior judicial assistant by the notification number 4, February 2016. So, in response to a notification calling for options from interested person to fill up the post of court officer, petitioner applied and by notification dated 18th of April 2016, petitioner was appointed as a court officer. So, it is the submission of the learned counsel to the petitioner, notwithstanding that he being promoted to the post of court officer on in the year 2016. he- the petitioner has not been considered for the next higher post of assistant registrar in spite of his seniority in the FIDE cadre. So, learned counsel for the petitioner submits that the post of a court officer is a class 2C.
My lord.
Class 2C post as notified under the Schedule 1, Rule 11 of the Guwahati High Court Service Rule 1967. So,
Schedule 1, Rule 11.
it is submitted that notwithstanding his claim to be considered for the next higher post, his claims had always been overlooked. So, learned counsel for the petitioner submits that his the reason why the petitioner is overlooked is because of the rider in the appointment order, the post of court officer, that his seniority
At page 18 of the writ petition. Last paragraph.
his seniority in the with the rider in the promotion order to the next higher post of court officer, that the incumbent will maintain his seniority in the original cadre, i.e. senior judicial assistant, and further promotion will be considered on that basis. Learned counsel for the petitioner submits that this aspect of the matter was considered in a writ appeal by this court and by a judgment rendered in writ appeal number 5 of 2023 and 71 of 2023. Writ appeals number so and so decided on 28/3/2024 by a division bench of this court. The the court has held that the rider, a similar rider, which was reflected in the promotion order of the incumbents in the said appeal, will not operate as a bar for their confirmation in the higher post. He submits that in that view of the matter, his claim for being considered for the next higher post could not have been overlooked by the registry, and he ought to have been permitted to submit his application in respect of the said post and be permitted to participate in the selection process, ensuing selection process. So, being agreed, the writ petition has been filed. So, this court, while issuing notice on 3005/2024, kept the prayer for interim relief open for consideration. So, on 10/6/2024, upon submitting before the court that an IA has been filed praying for interim orders, the matter was directed to be listed expeditiously along with the IA number 1769 of 2024. So, the said IA, the said writ petition along with the IA is being listed before the court today. Stock counsel for the petitioner submits this IA has been filed seeking urgent orders from this court to permit the petitioner to participate in the ensuing election process for the post of assistant registrar to be held on 12/6/2024 as per notification number so and so. Learned counsel for the petitioner submits that there is no express bar under the rules nor any notification pointed out before the court to which may reveal that the petitioner is not qualified to hold and be permitted to participate in the state interview. Mr. G. Bosho, learned counsel appearing for the Guwahati High Court. Submits that what is your submission? That he has no instructions in the matter.
My lord, I need instruction on that. And
He requires instructions in the matter, and the petitioner has come, has belatedly filed the IA, and therefore no interim order is called for at this stage. Correct. Learned counsel for the parties have been heard. On a pointed query by the court as to why the interim order in the writ petition was not pressed on a day when the matter was called for, learned counsel for the petitioner has referred to the notification memo number so and so dated 7/6/2024, stating that on a day when the notice was issued, there was no intimation given that the selection process for the post of assistant registrar will be called for shortly. So, upon being aware, being aware of the said notification, which was issued on 7/6/2024, this IA has been filed. The pleadings on record have been carefully perused. The judgment pressed into service has also been carefully noted. So, the ratio of the writ appeal being so and so number decided on so and so date is with regard to the right of confirmation of the incumbents therein at their higher post in view of the rider in their appointment/promotion orders that their seniority in the original post shall be maintained. So, on the facts of the case therein, the appellate court held that once the posts are vacated, once the original posts have fallen vacant, pursuant to the promotion of the incumbents therein, and those vacant posts have subsequently been filled up by other candidates, there is no scope for the incumbents therein to be reverted back to their original posts. And therefore, although the rules have not been put to challenge, the rider in the notification will not operate as a bar in confirming their, in issuing appropriate confirmation orders in respect of the posts to which the petitioners have been promoted. Stop. Para. Coming back to the facts of the case, the judgment pressed into service by the learned counsel for the petition will have no relevance in view of the fact that the issue here is the denial of the claim of the writ petitioner to participate in the selection process for the next higher post in to the post of assistant registrar. There is no issue raised in the present proceedings that he's he's not a confirmed. Is he confirmed?
There is no order confirming his service.
The question of confirmation of the writ petitioner in the post of court officer is not an issue urged in the present proceedings. So be that as it may, upon careful perusal of the rules, it is seen that Rule 7 of the so-and-so rules
Rule
define gazetted officers. Stop. The schedule 1 appended to the rules
11. Rule 11.
show that court officer is a post known as the gazetted officer under class 2 within bracket C. The post of court officer is shown as under class 2C along with the post of administrative officer, judicial, stamp reporter, protocol officer, assistant librarian, and senior systems officer. So, protocol officer has been reflected as an ex-cadet post.
Madam, this is not ex-cadet post. Now it is n-cadet. This is a mistake in the book, Miller.
All right, strike it out.
It is n-cadet since 1991. This is a typographical mistake.
Coming back to Rule 7 of the
N-cadet.
under sub-rule 2, under sub-rule 3, it is provided that the assistant registrar shall be appointed from amongst the state judicial service grade 3 or by promotion from the gazetted officers of the High Court's service belonging to class Roman 2 within bracket B, comma Roman 2 within bracket C, or Roman 2 within bracket D, or from among advocates of not less than 5 years continuous service at the bar. The council, standing council for the High Court has not been able to point out that there is any amendment or addendum to the rules as prescribed. Stop. If Rule 7 is to be read as prescribed, it is seen that the feeder cadre to the post of assistant registrar. One of the feeder posts to the post of, for promotion to the post of assistant registrar is from the gazetted officer under class 2C. Stop. Under such circumstances, where there is no whereas there is no dispute that court officer is a class 2C post under the rules, and class 2C posts are shown to be feeder cadres to the post of assistant registrar. Class 2C posts inter alia, along with class 2B and class 2D, are shown to be feeder cadres to the post of assistant registrar. Prima facie, it appears that the petitioner may have a claim for being considered and permitted for being considered for due selection and appointment to the post of assistant registrar. So this is the prima facie view expressed by the court, subject to such notifications and modifications as may be placed before the court by the standing counsel, the High Court. Under such circumstances, now what do you want to do? You want to hold it tomorrow, or you want to postpone it till the decision of the court?
Yes, ma'am. It may be postponed.
That is for you to submit.
Yes, ma'am. It may be postponed. ma'am.
The petitioner / the applicant is therefore permitted to participate in the ensuing selection process for the post of assistant registrar, notified by the notification number so and so, so and so, so and so. Stop. Dated so and so. However, the participation of the petitioner in the post of for selection to the and promotion to the post of assistant registrar will not confer any right on the petitioner, and such right, if any, will be made subject to the outcome of the writ petition. In the event the selection is proceeded with and the petitioner is permitted to hold, permitted to appear and participate in the selection process, the results in respect of the writ petition shall be placed in a seal cover.
Well, there is only one post. If there is only one post, if one person is appointed, then my lord, there is no point of keeping the result under seal cover. If lordship wants to keep it under the seal cover, then the whole result should be kept under seal cover. Because only one post, if one is appointed, then it
In
is.
the event the petitioner is selected an appointment, selected for the post of promotion to the post of assistant registrar, then any promotion or appointment order shall not be issued without leave of this court.
Well.
IA and the writ petition to be listed when? On
It has
26th?
fixed on 26th. no?
26th?
26th.
of June. Meanwhile, the counsel to the petitioner will take all necessary steps on the respondent
Was it taken?
within the course of the day.
Steps were taken.
Respondents are permitted to file their response. In the meantime, if the need to arise.
Well, registry has to be informed that I am allowed to be participating.
You'll have the order. You'll have the order after we write. Yes, your standing counsel is there. Can convey. When is the selection?
Tomorrow.
You'll have the order by the evening.
Kamlesh,
We thought we'll dispose of it in court, but since this is the only matter left, you permit, we can dictate it.
Well, only one thing, my lord. So far as the judgment that has been placed by the petitioner's side on the last occasion,
I've gone through the entire judgment, my lord. 5 or 6 judgments have been placed. In all those cases, my lord, the issue was the seller, my lord, sold the, my lord, goods to the buyer or purchaser. Thereafter, my lord, the purchaser was a registered dealer in a particular state, my lord. Thereafter, my lord, subsequently the registration was cancelled, and consequently, my lord, C-forms were also cancelled. So these things happen after the transaction were, my lord, taken up. So there, the Honorable Supreme Court has held that in that case, in such a situation, the seller cannot be held, my lord, responsible for cancellation of the C-form subsequent to the transaction.
Here the cancellation is even not. You have
No,
not
no,
been
I'm
able
not saying on that, but so far as the judgments were concerned, my lord. Here, my lord, the purchaser has denied that he has made,
Even
he has
when
undertaken
where the
any.
cancellation is there, then the seller has been held to be, purchaser has been held to be not, sorry, the seller has been held to be not liable.
No, no, still, I'm not on that, my lord.
Ah.
In the present case, the buyer or the purchaser, purported buyer or purchaser, he has denied of having any transaction with the present petitioner. That's what I want to point out.
So you make your assessments and
Yes, yes, yes.
whatever is permissible in law,
Well,
you do it.
and my lord, one more, my lord, Lordship may kindly record it while giving the order. Second, my lord, my lord, submission that my lord present petition, because is not maintainable because of non-gender of necessary party. That is the, my lord, purchaser is not a party here, as well as the authority who has registered the purchaser or has cancelled that, whatever information was furnished to us by the Gurgaon authority is not a party in the
They
present.
are not necessary parties.
No, I'm just, my submission may be recorded, my lord. That's
All right. Report it then. We can dictate it in court also. It is up.
no, I leave it to Lordship, man. I have nothing. Just I am pointing out, my lord, because of
Here,
that.
Sorry.
If you want to, Lordship wants to dictate
No, Lordship may dictate in the chamber also. No point waiting here.
wherever your Lordship is.
All right, we'll dictate it inside.
Fine.
It will be a long order. We'll
Lord.
dictate it. Yes, hard disposed.